The Supreme Court has never declared disability to be a suspect class, and thus the Constitution allows the government to discriminate against the disabled if they choose to do so. As just one example, George Lane was a Tennessee citizen who was required to attend a hearing at a Tennessee courthouse. Unfortunately for Lane, he was confined to a wheelchair, and the courthouse had no elevator. As a result, Lane had to crawl up the stairs by his arms to attend his hearing. To eliminate situations like this, Congress passed and President George H.W. Bush signed the Americans with Disabilities Act into law in 1990. The ADA prohibits companies from discriminating on the basis of disability against both their employees and their customers. The ADA defines a disability as a physical or mental impairment that substantially limits one or more major life activities. Major life activities include things like eating, drinking, breathing, walking, going to the bathroom, having sex, having children, and so on. While the Supreme Court hasn't decided many cases involving the definition of disability, the lower courts have. In general, they have defined the term very broadly. For example, because the ADA includes mental impairments, lower courts have ruled that employers cannot discriminate against employees because they are alcoholics, although they can fire employees who show up drunk for work. Another question that has arisen is whether disabilities that have been corrected, such as a nearsighted person who wears glasses, count as disabilities under the law. Lower courts have ruled that they do. The ADA also prohibits discrimination on the perception of disability, even if it's false. For example, if an employer fires an employee because they falsely think that the employee has cancer, they would be liable for an ADA violation. The Americans with Disabilities Act does not guarantee that disabled people will be eligible for all jobs, or enjoy all public accommodations. For example, the ADA does not require transit agencies to hire blind people as bus drivers. Disabled employees must be accommodated only if they can perform the essential elements of the job. Disabled customers must only be provided with reasonable accommodations that do not fundamentally change the nature of the experience for other customers. But that raises the often difficult question of what the essential elements of a job are, or what constitutes a fundamental change. A lawsuit filed by Casey Martin illustrates these concepts. Casey Martin was a professional golfer on the PGA Tour. He suffered from a disability that made it difficult for him to stand for long periods of time, and which also presented a risk of developing blood clots, or breaking his leg. As a result, Martin used a golf cart, which the PGA allowed in most tournaments. But it banned carts from its most elite tournaments, such as the US Open. Martin filed a lawsuit under the ADA, saying that allowing him to use a golf cart would be a reasonable accommodation. Casey Martin did not claim that he was an employee, so it was not an employment discrimination case. Instead, it was a public accommodations case. The PGA made two arguments. First, they argued that the PGA Tour is not a public accommodation and is therefore not covered by the Americans with Disabilities Act. Second, they argued that walking is an essential element of the sport of golf, and thus Martin is not able to perform an essential element of the game. This case made it all the way to the United States Supreme Court. The outcome depended partially on the answer to the simple question of whether walking is an essential part of the game of golf. But is this really a legal question at all? It sounds more like a philosophical one. As Justice Antonin Scalia said, either out of humility or out of self-respect, the court should decline to answer this incredibly difficult and incredibly silly question. But the court answered it anyway. And in a 7-2 decision, they agreed with Casey Martin. First, the PGA argued that the public accommodations provisions were meant to apply only to customers, and that Martin was not a customer. It argued that Martin, like an actor in a theater production, is a provider rather than a consumer of the entertainment that petitioner sells to the public. But the court disagreed, noting that the PGA offered anyone who paid a $5,000 fee to compete in a special tournament that allowed them to qualify for a spot in one of the majors. It said that the ADA applied to everyone at a sporting event, including the participants. Regarding the question of whether allowing the use of a cart would fundamentally change the nature of the game, the PGA argued that golf is a game of inches. It argued that a player who uses a golf cart will be less fatigued than a player who walks all day, giving them a competitive advantage. Furthermore, they argued that there is no essence of golf, and that the PGA should be permitted to offer whatever version of golf that it wanted. Again, the court disagreed. It argued that the fatigue from walking during one of petitioners' 4-day tournaments cannot be deemed significant. Furthermore, from early on, the essence of the game has been shot making, using clubs to cause a ball to progress from the teeing ground to a hole. There is nothing in the rules of golf that either forbids the use of carts or penalizes a player for using a cart. Golf is a game in which it is impossible to guarantee that all competitors will play under exactly the same conditions or that an individual's ability will be the sole determinant of the outcome. Of course, as the dissent noted, the same could be said for all sports. While Martin won his case, sadly, he never won a major golf tournament, and in October 2021, one of his legs was amputated. The passage of the ADA had a direct benefit for someone else, however. George Lane, the man in the wheelchair who was forced to crawl up the steps of a Tennessee courthouse, won an ADA lawsuit against the state. It required 25 of the state's counties to physically modify their building to guarantee access to the disabled.